Thank you, Peter, for that introduction, and thank all of you for turning out for this evening. What I've been asked to talk about is something that I've spent a lot of time researching. It can also be kind of an arcane topic. It's a little arcane, but also pretty darn important if you want to understand how the U.S. federal government works and how agencies of the U.S. government take laws that have been written and turn them into specific rules that we have to live by. So it's pretty important, even if sometimes it can be a little bit detailed. Really, this is what I want to talk about. This is one of my favorite Calvin and Hobbes cartoons, and it might be a little hard to read because of the size of the wording. Here's what's going on. Basically, Calvin says, I'm going to prove that there is no universal moral law in the universe by throwing this water balloon at Susie Durkins if the universe does not give me a sign that this would be wrong. And he said, any unusual happenstance would do, I'll take any sign. So he counts down, he gets no sign, he throws the water balloon at her, then down here, of course, she chases him, beats the crap out of him, and he's lying there on the floor in the last panel saying, why does the universe always give you the sign after you do it? That's tonight's topic. Regulation does things to people. Regulations tell us what we may do, they tell us what we may not do, sometimes they tell us what we must do. And if you don't believe me, just try getting on an airplane, ignoring airline and airport security regulations. If you do anything that's in violation of those regulations, that will be pointed out to you pretty quickly and you will be relieved of the offending items. Well, if you're going to do things to people, you have a responsibility, I would say a moral responsibility, to understand the consequences of what you're doing before you do it, not after. So the way Calvin did this is not the way we would like regulatory agencies of government to behave when they're telling us what to do or what not to do. We'd like them to understand the consequences of what they're thinking of doing before they decide to do it and before they do it. Presidents of the United States have recognized this for a long time. For about 4 decades, U.S. presidents have issued executive orders telling the executive branch regulatory agencies that they must conduct some analysis to understand the consequences of the really big regulations that they issue. And this is called regulatory impact analysis. It's a term of art used in the government, but basically it means 4 things. First thing with regulatory impact analysis is, understand the problem you're trying to solve. Identify either the market failure, which is a term of art in economics, or other problem that you're trying to solve. Secondly, look at alternative ways to solve it. Develop alternative solutions that may involve regulation or may involve other things that don't require regulation. Then assess the benefits of those alternatives and assess the costs of those alternatives. And do that stuff before you decide what you're going to do. We can also translate this into plain English. Figure out what problem you're trying to solve and what caused the problem. Figure out the alternatives. Figure out what each alternative would accomplish, and figure out what we have to give up in order to implement each alternative. Key concept there is, what do we have to give up? In economics, cost means what did you give up? It doesn't just mean some money that's paid out by somebody. It means what did you give up when you chose to do A instead of B? Some people might call these principles decision-making for dummies. I mean, if you think about it, it's kind of what you ought to do before you make any significant decision, right? I prefer to call it decision-making 101, kind of less negative connotations to that. So this is really about federal regulatory agencies, how you would do this sort of, take these basic elements of making a decision and apply them to regulation. Why does this stuff matter? Why does analysis of the problem matter? I got 2 stories for you on this. 2 contrasting approaches in 2 different federal regulations. One is a proposed regulation a couple of years ago I read from the United States Department of Agriculture mandating that all of the catfish processing plants in the United States, these are the places where catfish are killed and disassembled and packed. The catfish processing plants all have to have inspectors from the Agriculture Department. How well did the Agriculture Department analyze the underlying problem? I mean, they were trying to prevent salmonella on catfish that would then lead to infections, which is, it's a good thing to try to prevent. But what's the evidence that this regulation was needed? Well, There's a section in the analysis of this regulation called Need for Regulation, and this section simply only says the reason this regulation is being written is to implement a provision in the 2008 Farm Bill which required the Agriculture Department to implement this regulation. All right, that's a dangerous thing right there, when the best reason an agency can give for writing a regulation is Congress told us we had to, so we're doing this. You know, that's kind of like, I'm not responsible for the results, I'm just following orders. All right, what does the evidence say about the need for this regulation? Here are a few pieces of evidence that you actually find in the Agriculture Department's own proposal. Salmonella is rare because catfish is cooked before it's eaten. I mean, people don't make sushi out of catfish. There's been one suspected salmonella outbreak linked to catfish in the past 20 years that resulted in 10 illnesses. All 23 catfish processing plants in the United States have something called a Hazard Analysis and Critical Control Points Plan, which is a fairly detailed plan to identify places where contamination could occur and then put in place preventive measures to try to make sure that doesn't happen. 18 of the 23 plants already pay the National Marine Fisheries Service, which is part of the Commerce Department, to conduct inspections, safety inspections. And somehow from this information, it doesn't sound like there's a big problem. The Department of Agriculture's risk assessment extrapolated from data on poultry that there would be somewhere between 1,700 and 2,300 cases of salmonella infection. And then this regulation is needed to prevent that. Now, the reason that the department used poultry, the explanation for why, is because catfish are more like chicken than they are like hogs or pigs, or hogs or cattle. I'm not making this up. Okay, so, I mean, it looks like even based on the information that's in the Agriculture Department's own proposal, there isn't really a very significant problem that the Department of Agriculture is solving, because these salmonella outbreaks linked to catfish are very rare, and other federal agencies are already involved in regulating them. This is actually more about gaining bureaucratic turf, Agriculture Department gaining bureaucratic turf at the expense of the U.S. Food and Drug Administration. There's this little thing buried in there that talks about how the regulation might have different costs if they also define catfish in a different way that happens to cover fish similar to catfish that are imported from Vietnam. And it would be really expensive for the Vietnamese producers to do this stuff. So this also looks like trying to create an artificial advantage for the U.S. catfish industry at the expense of a competitor that produces a close substitute. All right. In contrast, Department of Interior every year issues bird hunting regulations that set the bag limits and hunting seasons for various kinds of migratory birds. And in the Department of the Interior's proposal and their regulatory impact analysis, it explains pretty succinctly that migrating birds are a classic example of a common pool resource. Nobody owns them. The only way you can claim one of those birds for your own is to shoot it. Because nobody owns these things, nobody has an incentive to try to get them to breed and reproduce and prevent overhunting. And so, unregulated, you know, the birds will be overhunted, the populations will dwindle, and they actually had some evidence that this in fact occurred before the international treaties that put in place regulation of hunting through bag limits and limits on the hunting seasons and so forth. So in that case, the Department of Interior very sensibly described a potential problem and presented some evidence that it actually exists. So it looks to me like there's a pretty good reason for the bird hunting regulation. You may or may not like the way that they implement it. You might think there might be other solutions, but they definitely identified a very real problem that needed to be addressed somehow. Why do alternatives matter? You all may have heard a little bit about this issue. And I don't want to open up an entire debate over the Affordable Care Act and the health insurance issue, but I do want to make this point. This promise that you can keep your health insurance plan if you like it was implemented through the Affordable Care Act by something called the grandfathering regulation. This is a regulation written by the Department of Health and Human Services that defines how much can a health insurance plan change and still be considered the same plan under the law, so that it then does not have to include a lot of expensive new mandates that are included in the law, additional coverages that had to be included. This is the regulation that was supposed to implement the promise, if you like your health plan, you can keep it. Well, I've read this regulation, and I've read the accompanying analysis, and it was put together pretty quickly, pretty slipshod, and it was put together in a way that would make it very difficult for an old health care plan to continue to be regarded as the same if it made a few changes here and there, and there's some pretty arbitrary decisions made in there. The Department of Health and Human Services, in its analysis of the regulation, briefly considered an alternative way of defining whether a health plan remained the same from one year or not. It's a concept called actuarial equivalence. It's a big term. Some of y'all in accounting and business school may know what this means, but the basic gist of it is actuarial equivalent. Two insurance plans are actuarially equivalent if the value of the benefits you get out of the plan is the same. Even though the benefits might be different, there might be different co-payments and so forth, if the value of the benefits is equivalent, then those plans are delivering the same amount of coverage in some sense to the customer. The Department of Health and Human Services said, nah, we're not going to use that standard because it would be too complicated. This is a standard, if they had done this, that would have allowed a lot more old health plans to continue to qualify as the same plan, which means fewer people would have been dropped off of old plans that insurers got rid of because they didn't think they would qualify as being the same plan. Bottom line is the administration could have saved itself a lot of grief by writing this regulation differently if it had done some serious analysis of the actuarial equivalence standard as well. Now, the funny thing about it is that standard actuarial equivalence is precisely the concept that's used to define, if you go into one of the healthcare exchanges and look at health insurance plans, they are rated bronze, silver, gold, platinum based on the benefits that they deliver. That's actuarial equivalence. All the plans rated silver are delivering a similar level or value of benefits, even if the benefits are somewhat different and some of the provisions are somewhat different. So at the same time that HHS was saying, no, that concept is too complicated to use in grandfathering old health plans, it was preparing a regulation for new health plans in the exchanges that use that very same concept to define which type of plans are similar to each other to live the same way. So that's why looking at alternatives matter. Whether you like the healthcare law or not, I think the administration could have saved itself a lot of grief if it had looked at this alternative when it was writing the regulation. Why does good benefit analysis matter? Now, this is a regulation that I recently read and actually wrote a comment on and submitted it to the agency. The U.S. Food and Drug Administration proposed a rule essentially saying that manufacturers of all food for animals have to have in place the same types of quality control and other processes that are required for human food. Basically, to make all animal food, whether it's feed for livestock or pet food or whatever, all animal food must be have the same manufactured with the same safety standards as human food. The Food and Drug Administration, this was a little odd, the Food and Drug Administration did not bother to try to estimate the benefits of this regulation. Now, usually when federal agencies issue a regulation, they're pretty good about trying to estimate the benefits because that's the reason they're doing the regulation. But instead, the FDA just said, well, it's going to have this advantage and that advantage and that advantage. It's going to prevent some salmonella infections. It's going to prevent some sickness in animals. And they mentioned a couple other things that turned out that they speculated would happen, turned out probably aren't true. But the FDA didn't try to estimate how many infections would be prevented or what the value of them is, even though they routinely do this for other regulations. So a co-author and I took a shot at estimating these benefits and found out that the most likely estimate of the benefits of this regulation is about $13 to $17 million. Most of that is the value of avoided salmonella infections. And that's because, that's not because animals are getting infected with salmonella. That's people who mishandle pet food and then get the pet food or get their hands in their mouths where the pet food has salmonella on it. And then they put some of the biggest instances of salmonella infections from pet food have been improper handling of frozen mice to be fed to snakes. Think about it, people putting their hands in their mouth after touching dead mice without washing their hands Okay, so that's the kind of thing this regulation is trying to prevent, but the benefits are pretty small. The Food and Drug Administration estimated the cost would be between $87 and $129 million a year. I don't know if that cost estimate is any good. All I know is it's a heck of a lot better than any likely benefits this regulation is going to produce. But since we took the trouble to try to estimate the benefits, we knew, even though the FDA didn't, that most of the benefits come from preventing salmonella infections in people. People get salmonella infections from mishandling of pet food. So if you restrict the regulation to pet food, you get almost all of the benefits, and you get all the benefits that accrue to people. You get almost all of the same benefits if you restrict it to pet food at a much lower cost, because you don't have nearly as many manufacturers subject to the rule. You're only trying to make pet food safe enough for people to handle, rather than trying to make all animal food as safe as human food. Finally, why does good cost analysis matter? And cost is a thing, it's a slippery term. And a lot of people kind of carry around in the back of their heads, wait, you know what, let me take a poll. How many folks are economics majors, or at least have had like a year of economics? Okay, goodly portion of folks, not all. Okay, all right, let me explain this. To an economist, cost means opportunity cost. What did the decision maker, or what does society give up in order to pursue this course of action instead of that course of action? What did you give up in order to get what you got? To a lot of people, kind of carry around in the back of their heads that cost just means money. And in the case of regulation, we know that that money is paid out by businesses. And that money paid out by businesses comes from a suitcase called profits, which aren't earned anyway, so who cares about costs? Well, I'm going to give you a little bit different perspective on costs. Costs are lost opportunities, not just money that somebody pays out that they never deserved to have to begin with. Here's an example. A couple of years ago, a co-author and I looked at what's the cost of the enhanced airport security measures put in place after 9/11 to protect us from terrorism. Now, realize, we're not saying it's a bad idea, we're just saying we want to know what it costs. The first and most obvious example, and it's the answer a lot of people would probably give, would be, well, gee, the federal government took over the whole process of airport security, so I guess the cost is the part of the Transportation Security Agency budget that is devoted to airport security. And that's a big number, $4.3 billion in 2005. It's gotten bigger since. But that is by no means the whole cost to air travelers or society. That cost, the TSA budget, is funded through taxes on airline tickets. So there's a price increase on airline tickets that's passed through to the customer. Because it costs more to fly, fewer people fly. They substitute other modes of transportation. Because people substitute other modes of transportation, which would have been less preferred, except for the price increase, there is a loss of value to consumers. And those of you who've suffered through many economics courses might remember the term deadweight loss. I was just trying to avoid using the piece of jargon. But there is a reduction in value to airline customers, or a reduction in a loss of value to the people who would have flown if it were cheaper, but now they don't fly and they have to take some other mode of transportation, or they don't travel. And we did a little ballpark back to the envelope estimate, and that found out that was a little over $2 billion. But wait, there's more. A principle well recognized by the Department of Transportation and transportation economists is that people's time has value. And if you do stuff that either increases or decreases travel time or waiting time, that is either a cost or a benefit, depending on whether you're doing something that increases people's waiting time or reduces people's waiting time. Well, if people spend more time waiting around in airports, going to airports, their time has a cost. We ballpark that at around $2.76 billion. But that's not all. You notice, those all got converted into monetary terms. You might say, okay, fine. People have to wait longer. Some people drive rather than fly. What's the big deal? Well, there's another interesting cost here. I said some people are now driving rather than flying. Typically on shorter distance flights. I mean, not many people who wanted to fly from Charleston to San Francisco are now going to drive, because airline travel is more expensive, it takes longer. But I'll tell you what, I live in South Carolina, I regularly travel to Washington, D.C. Most of the time I drive, because flying is more of a hassle. Well, it turns out statistically, highway travel is a lot more dangerous than air travel. And there's a group of economists at, I'm blanking on the university, it's a major university. The article was published in the Journal of Law and Economics a few years ago, calculated that the enhanced airport security measures put in place after 9/11 led to, or associated with, an additional 116 deaths on highways in the fourth quarter of 2002, that's where the data is from. That's because flying became more expensive, more of a hassle, and on some short distance trips, people substituted driving for flying. Does this mean the airline security measures are a bad idea? Not necessarily. All it means is that here's an accurate idea of what they cost. And then let's compare that to how much good we think they're doing to figure out whether either we want to keep doing it or we figure out, okay, is there maybe some way you can modify this with lower the cost, but still get most of the safety benefits. I mean, you can't make a decision based on cost alone. My only point is there's often a lot more to costs than just some money that you see somebody take out of his or her pocket to comply with the regulation. Well, how well do federal agencies generally analyze this kind of stuff? I gave you a few examples earlier where Department of Interior seemed to do a good job analyzing the problem on the duck hunting regulation. Department of Agriculture didn't seem to do such a good job analyzing the problem on the catfish regulation. But in general, how well do agencies do this? For a number of years at the Mercatus Center at George Mason, we have had a project that actually tries to evaluate how well federal agencies do the major aspects of regulatory impact analysis, which executive orders signed by presidents tell them they are supposed to be doing. How well do agencies do this when they issue their biggest, most important regulations? And it's kind of like a giant exercise in grading papers. We have a group of economics professors around the country and some researchers at the Mercatus Center who are trained in regulatory impact analysis, who read these things and evaluate them. We look at a half a dozen criteria that come, as I said, from the executive orders, the current executive order that governs how agencies are supposed to do this, and something called OMB Circular A4, which is the President's Office of Management and Budget's guide to federal agencies on how you're supposed to be doing this stuff. And they look through the regulatory impact analysis, that's what that acronym is, RIA. They read the agency's regulatory impact analysis, and they read the Federal Register Notice, where the agency lays out its justification for the regulation. And they evaluate we evaluate the analysis based on a half a dozen criteria. 4 of them are the things I already mentioned to you. How well does the agency analyze the problem it's trying to solve? How well does the agency elaborate and analyze alternatives? How well does the agency analyze the benefits or the other things it's trying to accomplish with the regulation? And how well does it analyze costs? We also look at 2 additional questions, which is, to what extent does the agency claim that it used the results of the analysis to make decisions? You'd hope that's a pretty important thing, right? We don't just want Calvin to think about what will happen if he throws the water balloon at Susie Durkins. We want him to make a decision based on that knowledge. So we look to see whether the agency makes any claim to have used the analysis, and if so, how significantly did the analysis affect its decisions. And we also look at specifically how cognizant of was the agency of the what are called the net benefits of the regulation, that is, benefits minus costs. You would hope that most regulations create benefits that exceed their costs. We're not asking here, did the agency make sure that the benefits exceed the costs? We're simply asking, did the agency demonstrate that it was aware of the relationship between benefits and costs? And did it either try to maximize that, or did it give a coherent explanation of why it did something else? Which might have been simply, well, we couldn't maximize the difference between benefits and costs because the law says we have to issue a regulation that does this instead. That's fine. So this is the question of how transparent is the agency about how it's using this information. This is not an evaluation of whether the folks reading the regulation thought it's a good idea or a bad idea or not. It's just a question of how well done was the analysis and how cognizant of the analysis was the agency. On each of these criteria, we award a score between 0 and 5 points 5 is something that's relatively complete. A 0 is when there's just no relevant content at all. 6 criteria, maximum 5 points, yields a total possible score of 30 points. The highest score we've ever seen is 28 out of 30 points, or 93%. That's good enough for an A in my book. The average, however, tells a different story. That best one ever is a lot better than most. The average is actually just over the half of the available points, 15.4 points out of 30. Translates into 51%? No.
What was
Okay.
that best score?
Excuse me?
What was that best score? Which,
The, what, the 15.4 or the high one?
What agency?
which agency?
Oh, okay, the high one, the 28 out of 30, that was a regulation issued jointly by the Environmental Protection Agency and the Department of Transportation, setting corporate average fuel economy standards for automobiles. And maybe the fact that you had 2 agencies working on it had something to do with the fact that the analysis was that thorough, I don't know. But then this average, you know, there's some above that average, some below that average. The worst one I've ever seen, was from the Social Security Administration. It was a regulation setting criteria for scheduling courtroom time for administrative law judges who settle disability claims. And basically there was virtually no analysis at all. So they got like 3 points because there was virtually no analysis. Now, one of my colleagues at the Mercatus Center used to be chief economist at the Social Security Administration when this regulation was being implemented. And when he explained to me the reason they were doing it, I thought, well, gee, that sounds pretty reasonable. The problem is there was no accompanying analysis that laid that out. Here's the average scores by year. Statistically, there isn't really a difference between these. So really what this is showing you is that regardless of the year, the last year of the Bush administration or the first 4 years of the Obama administration, the scores are all hovering around the average. Here are the scores when you break them up by criterion. The criterion with the lowest average score is analysis of the problem you're trying to solve. This should really concern you. I mean, it concerns me. If you haven't done a good analysis of the problem you're trying to solve, what good does it do to do everything else? If you don't know what you're trying to accomplish, if you don't know the source of the problem you're trying to solve, how can you possibly write a regulation that creates an effective solution? An average score of 2.1. I flashed through the list of scoring criteria real fast a few minutes ago. An average score around 2 means that there's some discussion and there's maybe some evidence, but it's far from complete or comprehensive. So on average, that's what it is. By the way, on all of the criteria, you can find some regulations that do get a score of 5. There are some individual cases where they're pretty good, but on average, well, let's just say the really good ones are the exceptions rather than. Here's something else on actual use of analysis, or the extent to which the agencies claimed to use the analysis to make their decisions. You know, federal agencies, when they propose regulations and when they finalize regulations, actually have to write something up that says, here's why we are doing this. And that explanation is very important because if the agency can't give a coherent explanation of why it's doing this, a court might invalidate the regulation, saying, well, no, you haven't given an adequate you have been arbitrary and capricious. You haven't given an adequate explanation of why you're doing what you're doing. Now, courts defer greatly to the agency's judgment. But what's interesting about this is we found in 2/3 of the cases, that's the green part of this segment, in 2/3 of the cases, the regulation got a score of 0, 1, or 2. And a score of 0, 1, or 2 on this criterion basically means we can't find any evidence in what the agency wrote that it used the analysis to make any decisions. Maybe the analysis had some influence behind the scenes. Maybe the economists were talking to the lawyers and you know, the final regulation is very different from what would have been written if those conversations hadn't occurred. But the only thing we can observe is what does the agency write down when it issues the regulation? And in 2/3 of the cases, we can't find where the analysis that agencies are supposed to do, according to executive orders from the president, we can't find evidence that it had any effect on the agency's decision. Now, the final thing I'll mention is in the course of doing this project, we've looked at actually now more than 108 regulations, 108 really big regulations. We've scored them according to how well the agency analyzed the problem, the scope of the alternatives, all kinds of stuff. And in those scoring criteria, we have sub-questions where we'll have sub-scores and all kinds of things. So we have a lot of numbers, a lot of data that we can play around with and try to figure out, are there any interesting patterns that help us understand how the federal regulatory process works, that help us understand the linkages between analysis and how regulations are written? Is there anything that we can learn from this that helps us understand how we might improve the federal regulatory process in order to get better regulations that are more effective, regulations that are lower cost, whatever. Well, here are the major things we found when we take all of this these score data we have and do all kinds of fancy statistical work with it. Here's the bottom line results. One of the things we find after you control for other factors is there just ain't much difference in the quality of analysis on average between administrations. Now this is really important because it means if we're dissatisfied with the quality of analysis agencies do, and I am, what that first result tells us is you're not going to change it by changing the people in charge. It's an institutional problem regardless of which party is running the White House and the regulatory agencies. So that the way to get some significant improvement in what agencies are going to do is to actually change the institutions of the regulatory process itself, not just say, oh, well, we got to vote a new group of guys in and they'll do better. One difference we did find between administrations, though, is that basically different administrations seem to let the agencies they're prone to trust more get away with doing worse analysis. So in the Bush administration, agencies that are kind of more conservative, and there's some political scientists that came up with a way to rate federal agencies based on their missions and their policy preferences, where they're kind of more conservative or more liberal, and we're just using that data that they came up with. But agencies that are rated as more conservative by these political scientists have lower quality analysis in the Bush administration, but better analysis in the Obama administration, and vice versa. In the Obama administration, it looks like the agencies that are kind of more liberal can get away with doing worse analysis. And in the Bush administration, those agencies had to do better analysis in order to get their regulation through. It kind of fits with your intuition. If the president is trying to control what all these regulatory agencies who work for him do, some of them will get more of a free pass because it's like, okay, Department of Defense, we trust you guys. Occupational Safety and Health Administration, I'm not so sure, we're suspicious. Another thing we found, there's a phenomenon called midnight regulations. That's when at the end of the presidential term, agencies rush to get regulations finished and out the door and in the Federal Register so they can take effect. And they'll rush these things. And we can identify these, and we found at the end of the Bush administration, these midnight regulations, they were trying to get out the door between between Election Day, when they knew that a different party would be occupying the White House. Between Election Day and Inauguration Day, those regulations have lower quality analysis. Also, we found that when we evaluate the quality of analysis and it's better, agencies are also more likely to have claimed they used it. I don't know if that means if you build it, they'll come. If the agency's analytical people do a better job, that means the policy people are more likely to use the results. Or if it means if an agency's more prone to use the results of analysis anyway, they're going to invest more and do a better job of doing analysis, so they've got something they would actually want to rely on. I'm not sure which way that goes. A few other things. We can, since we've evaluated a bunch of regulations adopted by executive branch agencies, cabinet agencies, we have an idea of kind of what the norm is. Then we can go out and look at regulations from other types of agencies and compare them, or look at other types of regulations. So we've done some research on that. My colleague and I took a look at some regulations from the Securities and Exchange Commission, which is an independent agency, not under the executive orders that require this kind of analysis, but the Securities and Exchange Commission is under a legislative requirement from Congress to do some cost-benefit analysis of its regulations. So we said, hey, how well does the SEC do? Took a sample of SEC regulations, evaluated them. Turns out they do a lot worse than the executive branch agencies. By the way, the Securities and Exchange Commission recognizes this and has promised to do better. So the next thing we want to do in a few years, once they've had time to do it better, is go back and look and see. There's also an interesting type of regulation the federal government can issue called an interim final rule. The normal regulatory process, in the normal regulatory process, an agency issues a rule by first putting out a proposal saying this is what we're thinking of doing, this is the rule we're thinking of writing, and getting public comment on it. And then after the agency gets public comment on it, it revises it and puts out a final rule. That's what agencies are normally supposed to do. There are also ways legally that agencies can just go right to that final rule and say, even though we haven't gotten any comments from the public, this is what we're doing. And if you want to comment on it, we might go back, we might take comment. If the public wants to comment on it, we might revise it later, but we're going to put it into effect right now. This was done in the Bush administration with a number of Homeland Security-oriented regulations in the years following 9/11. This was done in the Obama administration in the first swath of regulations implementing major portions of the Affordable Care Act. In both cases, if we just sit down and score those, evaluate them the way we evaluate the other ones, we find that the quality of analysis is a lot lower. I mean, these regulations that are put in place without getting comments from the public first are truly rush jobs where decisions get made on the basis of something other than any kind of a rational analysis. What else we found? We found the longer OIRA review. There's an office within the Office of Management and Budget that reviews federal regulations before they can be issued. This is called the Office of Information and Regulatory Affairs. Anybody heard of a guy named Cass Sunstein? Former law professor at the University of Chicago. Okay, he was the most recent head of OIRA. He recently stepped down and was replaced by somebody I've actually met. But in any case, we found that this office is in charge of trying to ensure that federal agencies do good analysis, and we find that actually the longer they take to review the regulations, the better the analysis is. And finally, we did some research looking at some possible reforms to the regulatory process and using the score data found in because there are a lot of reforms to the federal regulatory process under discussion in Washington now. And we found that some of those probably would lead to higher quality regulatory analysis by federal agencies. Why does any of this matter? This matters, this analysis stuff matters because this is what we want to avoid. We want to avoid being in a position where regulatory agencies or anybody else are sitting there saying, why didn't I think this through first instead of just acting before I knew what I was doing? And short of all the jargon, of all of the words, all the verbiage, all of the, rather complex stuff, some of which I went through pretty quickly, short of all that, this is what we're trying to accomplish. This is what we're trying to avoid and why we're doing it. And this is actually why at the Mercator Center we undertook this research project to try to figure out how well federal agencies are looking before they leave. And with that, I'll shut up and talk about whatever you all want. Who's got questions?
What was the worst executive branch agency? What was the best?
It's hard to say a lot about individual agencies. We looked at 108 regulations over 5 years. So you've got a lot of agencies who only maybe issued a few regulations in that period, and that's not enough to generalize. We do have, there are some agencies that have issued like more than 4 regulations in this time period where maybe it makes sense to look at them and compare them. And actually, if you go to www.mercatus.org, you can find a piece that does some of those comparisons that we just posted a couple of days ago, looking at how well agencies analyze the systemic problem they're trying to solve and how well they analyze benefits or other outcomes. And we have maybe 8 agencies that issued more than 4 regulations. And if you kind of put their scores side by side, the similarities are stronger than the differences. So a lot of folks a lot of them are kind of in the same range. There's a few of them that stick out in some cases for sort of odd reasons, like Interior Department sticks out as doing better. But that's because the only Interior Department regulations in the sample are the annual duck hunting regulation, where they issue this regulation every year, which means they get a lot of practice in doing the analysis, right? And in fact, they recycle the analysis document from one year to the next. It just says the same thing until they do an updated survey of duck populations, and then they redo it. So that's kind of, that one seems to be better, but it's kind of unusual. The other thing I've noticed that stuck out is there are a pair of regulations that were developed jointly by the Environmental Protection Agency and the Department of Transportation, implementing corporate average fuel economy standards. And one of them was the best we ever saw. The other one scored pretty darn high as well. And we have one other regulation like that that was only done by the Department of Transportation that scored reasonably well too. So I'm not sure if that says something about you get a better regulation if two agencies work on it, or if there's something unique about those two agencies working together, or if it really just means the Department of Transportation has always thrown a lot of resources into doing the analysis of this regulation, so it's going to be something to be sure of. Yeah.
Are there any incentives for an agency to put more time and effort into their analysis? Because from what you said, it just goes on the floor and they can consider people's comments. And it's just considering. I'm just wondering will they ever change?
The principal incentive for executive branch agencies to do a good job in their analysis is review by the Office of Information and Regulatory Affairs. That's an office within the Office of the Budget, and the administrator of OIRA, as it's called, and the people who work there, I kid you not, refer to themselves as OIRanians. I know some. The administrator of OIRA has the power to quote, return a regulation to an agency for further consideration, which really means the regulation's dead. So you don't want to do such a bad job on the analysis or have such an odd regulation that the administrator of OIRA, who was appointed by the same president who appointed you, looks at it and says, no, this can't go. And this has happened on occasion in both Democratic and Republican administrations, where because OIRA's job, they have a little different perspective because they're part of the White House and they're thinking government-wide, and it's an office full of people who think about the kind of stuff I've put up here 24 hours a day, and they're career federal employees who view their job as making sure agencies do good analysis, they meet some standards. So you've got some incentive there where it needs to pass at least some minimum bar, or else OIRA won't let it get through. And we have evidence that matters. I don't think it's nearly a strong enough incentive, though. A stronger incentive would be, say, writing legislation telling agencies that they have to do this kind of analysis. Telling them that, and then subjecting that analysis to judicial review, where someone could challenge the regulation on the basis that, no, the supporting analysis was isn't good enough. And have a judge decide, has the analysis met a minimum standard of quality, and has the agency adequately explained how it used the analysis, or what other factors led it to adopt the regulation if it's ignored some aspects of it. Because it's agencies don't want to do things that courts are instructing. So that would be a much stronger incentive, as evidenced by the fact that the Securities and Exchange Commission has a requirement in its legislation to do cost-benefit analysis. Several years ago, it lost several really important court cases, and so the SEC has come out and said, okay, we are going to do better. Here's our new framework for doing this kind of analysis. They really are making an effort to improve because they know judges will overturn the regulations if they don't approve. I'm sorry, did you have a question here? No? Okay. Oh, okay. Sorry. I was over here and I saw something moving out of the corner of my eye. Must have been you.
How much flexibility do the agencies have when they write these regulations versus what is dictated by law or mandate?
Yeah, how much flexibility do the agencies have? It really depends how the law is written. Let me give you two examples, both of the agency I worked for, the Federal Trade Commission. The Federal Trade Commission Act gives the Federal Trade Commission the job of stopping, preventing, quote, unfair and deceptive business practices. That's a pretty broad mandate. And in fact, for a long time that had meant different things over different time periods. The FTC currently has a set of standards that say, okay, this is what we mean by deception and unfairness, just to give everybody a better idea of, here's what you would do that would violate the law, and here's things that aren't violated. So that's really broad. On the other hand, shortly after I left the Federal Trade Commission, Congress passed a piece of legislation called the Fairness to Contact Lens Consumers Act. Among other things, this legislation mandated that your eye doctor, how many folks wear contact lenses? All right, yeah, this is an important one. This legislation mandated that your eye doctor must give you a copy of your contact lens prescription so that you can shop around and you don't have to buy lenses from your eye doctor. I mean, if you've been wearing contact lenses for a long time, you may remember a time when you would get a prescription for contact lenses from your optometrist, and the only place you could get the contact lenses was from your optometrist. Or you have fairly limited options. So anyway, Congress passed this law mandating a very specific regulation. The FTC must issue a regulation saying that eye doctors have to give you your contact lens prescription. And the reason it was so specific is the FTC on its own years ago had already adopted that kind of a regulation for eyeglass prescriptions. And so Congress was really saying, hey, you know what you did for eyeglasses, do it for contact lenses now. Interestingly, this will say something about the priority that the careful analysis takes sometimes. There was another provision in the same legislation that required the Federal Trade Commission to conduct a study of competition in the contact lens industry. And that study might have told us something about whether that regulation was necessary or not. The deadline for the FTC to issue the regulation was 6 months after the legislation passed. The deadline to conclude the study was either 12 or 18 months after the legislation passed. So, I mean, they wrote the law so that the analysis wouldn't be done until the regulation was issued. That's because, some folks in Congress had very strong preferences to have this regulation adopted, regardless of what the FTC's own analysis might find.
So, what about agencies that sort of fall out of the scope of things, right? Agencies that are sort of independent and when they introduce regulations, is there any sort of review process that is? So I'm thinking, recently, right, Federal Reserve, for example, has taken on regulatory rules that they didn't have before, and Congress has given them that authority, but is there any sort of oversight on the regulations and so forth and regulatory powers that they are given and the types of things that they do? Or?
Oh, God. You've asked a question that's horrendously complicated with multi-layers of answers, and I'll try not to put everybody asleep doing this. Okay. The distinction you're making, first off, there are agencies that are clearly part of the executive branch. The president can fire the heads of those agencies for no reason, which means they darn well better do what the president wants them to do. Those are, anything with department in its name, Department of Homeland Security, Department of Energy, also the Environmental Protection Agency, and a few other government agencies that aren't called departments, but they're clearly part of the executive branch. They work for the president can fire the political appointees. Then there are agencies referred to as independent agencies. They're more independent of the president. They're sure as heck not independent of Congress or politics, but they're more independent of the president. Typically, these are agencies that are headed by a group of people rather than one. A lot of them have commission in their name, like Federal Trade Commission, Federal Energy Regulatory Commission, and so forth. And a lot of these entities will have maybe 5 commissioners appointed by the president, but only 3 can be from the same political party, which means essentially they're less responsive to presidents, which automatically means they're more responsive to Congress, which is why Congress likes independent agencies. And then there's a few other oddballs that are independent of the executive branch, but not quite so responsive to Congress either. And the ultimate example is the Federal Reserve, because the Federal Reserve doesn't get federal appropriations. The Federal Reserve gets its own money, right? The Federal Reserve prints money. And so when the Fed spends money, Actually, I guess the money the Fed spends technically comes from the profits. It's the interest on it earns from the federal government bonds that it holds. But in any case, the Federal Reserve traditionally has been an independent agency. Okay, those independent agencies, because currently it is widely believed that the president cannot fire their heads, except for cause, which runs into tremendous litigation and controversy. Those agencies do not have to submit their regulations to OIRA for review. So there's no review mechanism before the regulations are issued. As a footnote, it turns out that when presidents have written executive orders requiring regulatory impact analysis, in both Republican and Democratic administrations, legal advisors to the president have said, you have the right to fire heads of independent agencies. You'd have to litigate it, somebody would sue over it, but you have the right to do that. Or at least they've said, certainly you have the right to tell agencies, independent agencies, they must do this analysis and they must submit their regulations for review. No president has wanted to take on that issue and take on a fight with Congress over that. So it's a little squishy. The independent agencies, yeah, they're not subject to the executive order, but legally they probably could be if a president wanted to fight through that issue. And the fight would be with Congress, because Congress would be saying, hey, these are the people who always do what we tell them to do. What's the president doing trying to tell them what to do? So the only kind of review of how those agencies make decisions or whatnot happens if there happens to be something in the particular statute authorizing that agency that says they have to do some kind of analysis. Then there might be some judicial review. So Securities and Exchange Commission, the Commodity Futures Trading Commission has similar requirements. There are a few agencies. Now, you mentioned the Fed taking over new responsibilities. There's this new Consumer Financial Protection Bureau that's housed in the Fed but isn't responsible to the Fed, but it gets its budget from the Fed. And as best I understand, there is some controversy over whether that new entity has to do any kind of economic analysis of its regulations or not. I've heard people say it's completely unaccountable and there's no requirement. I've also heard there is some kind of requirement buried in the legislation. I know the place to look for the answer. My colleague Martinez Hester-Purse, who is a financial industry lawyer. I mean, she didn't work in the industry, she's a financial markets lawyer who's worked at the SEC, did a big piece on all kinds of stuff on what's in Dodd-Frank and what it means. So there's an answer there somewhere. Either that or I could email her an answer. But anyway, so sorry, that's a long and hopefully understandable answer to a question that ends up being kind of complex. But other questions?
Yeah, I think you probably answered it, but, so you mentioned Federal Reserve and how they run a lot of these regulatory agencies. Now, is there a regulatory agency that regulates the Fed, or how's the Fed, is there any kind of, does anybody that regulates the Fed, like, how does that work?
The Fed is a very strange animal. Because the Federal Reserve, technically the Federal Reserve is owned by the member banks. And the country's divided up into regions, and there's a Federal Reserve Bank in each region, and technically those Federal Reserve banks own the Fed, which means you would think that the sort of supreme board governing the Fed, the Board of Governors, would be chosen by the regional banks. End of story. That's not how it works. Some members of the Board of Governors are heads of the local regional Federal Reserve banks, and they rotate in and out of these slots where there's, I forget the numbers, there's like maybe, I don't know, 10, I'm making this up, there are like 10 regional banks, Federal Reserve banks, and there are like 6 slots on the board that are for the bank presidents. So not all the bank presidents run the board at the same time. And the rest of the members of the Fed Board of Governors are appointed by the president with the advice and consent of the Senate, just like a political appointee in any government agency. And the chairman of the Fed is appointed by the president. There is no regulatory agency that sits over the Fed, and really the Board of Governors operates like a for when the Fed's doing regulation, the Board of Governors operates kind of like an independent regulatory commission. So it's the Board of Governors that's making the regulatory decisions. So it's like a regulatory commission, but instead of 5 members, it's more. And then when the Fed proposes regulations, it has to play by the same rules as other agencies. It has to give the public opportunity for notice and comment and whatnot. But yeah, nobody's really sitting there reviewing the Federal Reserve's regulations.
So they're kind of like this.
Yeah. Well, it's safe to say they have a heck of a lot of independence. Yeah.
Sir, a question for you. For the example you gave earlier about the catfish regulation,
Yeah.
you mentioned that it was only implemented because Congress wanted that specific provision implemented, and that said that there was maybe a bureaucratic play for the power on the agricultural side. So if Congress is using regulatory institutions in this way, why would they want to open regulatory institutions to judicial review over, for your example, before your suggestion, their analysis? And if Congress would or wouldn't want that, then how would that provision get pushed through? How would there be progress made on this issue?
Oh, okay, yeah, so you're saying, okay, if Congress is using regulatory agencies in this particular way, and wants regulatory agencies to do stuff that isn't really subject to any analysis or careful thought, why would Congress ever pass legislation saying all agencies must do this? I think the best explanation of how this could happen is through an analogy. Suppose you go out to dinner with a bunch of friends, and you agree that you're going to split the check. But you're going to order individually. And it's not like pizza or something where everybody has to agree. What do you think is going to happen to the size of that restaurant check compared to the sum of restaurant checks you would have if everybody went out to dinner and ordered on their own and paid their own check?
Whether it's higher or lower, it's not going to serve everyone's interest.
Yeah, somebody might be dissatisfied, but suppose you can order whatever you want, but you just all agree you're going to split the bill.
I'm assuming the answer's higher. I would feel guilty and order lower than what I wanted, but maybe someone else would order higher than they wanted.
Yeah, but
Neither of us would be totally satisfied. It wouldn't be on board for anyone.
yeah, I mean, if you have a conscience, you might order lower, or your order might not change. But some people are probably going to order more than they otherwise would have ordered. So the total restaurant bill is high. So, but everybody recognizes that could be a problem. And so if you're going out to dinner with friends, you probably take some kind of effort to make sure that doesn't happen. Either you agree that everybody's going to pay their own bill, or maybe if somebody wants to order something really expensive like a bottle of wine, it's just kind of understood that, well, we're not going to order this unless everybody agrees to it, or something. So that there can be cases where if you just, let individual people do what they want to do in a situation where everybody's sharing the cost, you get a higher cost than you otherwise would. Okay. The analogy with Congress and regulation is this. You have individual congressional committees that have jurisdiction over particular things, who might like to see their agencies expand, because it expands the committee's turf as well. I don't think the same committee that oversees the Agriculture Department oversees the Food and Drug Administration. So you have individual committees that will authorize and require regulations, and they're like the individuals ordering stuff. And while everybody in that environment might want to do as much as they can through their committee to further their own interests, there may also be some recognition at certain times that, gee, if we all do this, it's going to be a lot more costly than we want it to be. And so we are going to agree to some sort of general rule that'll help control some of that. Either control what the committees are doing, or control what, to some extent, what the regulatory agencies are doing. So we can't all, as members of Congress, order way too much food because we know we're sticking everybody else with the bill. And so that's the kind of thing. That's the kind of thinking that could lead members of Congress to step back and say, okay, in my role as a member of Congress, not a member of this committee, I agree that it would be a good rule to make agencies do this analysis, even though I know every now and then it might mean that, it'll make something I propose look foolish because the agency does the analysis, and it turns out that what I put in the law was really stupid. So people might agree that. There's a sort of similar mechanism in Congress now for budget, although it doesn't work very well. And that is, you have appropriations committees and subcommittees, which are the committees, those are the only committees that can actually spend money. And typically, the appropriations committees are divided into subcommittees with special jurisdictions, and a lot of times people become champions for the particular programs that they appropriate money to. But since the 1970s, each Congress has also had a budget committee. The budget committees act first and say, here are the general parameters, here's how much we're going to spend, here's how much we're going to divide it up among different appropriations committees. And the appropriations committees are supposed to pay attention to the instructions from the budget committee. So the budget committee is supposed to be kind of a restraint on what everybody else does. So there's an analogy there where, okay, you can see where members of Congress have kind of accepted that logic in the budget context. Now, since Congress can always pass a law that changes the previous law, when the budget committee, when Congress passes the resolutions from the budget committee on the budget, later on the appropriators can do something else, and if Congress passes it, that's what becomes law. So it doesn't work perfectly, but same general idea.
Any other questions?
Take another one or two if I promise not to talk so long.
All right, well, I appreciate you all coming out this evening. I'm sure Mr. Ellig would be, Dr. Ellig would be willing to stay for a little bit, and if anybody wants to come out and ask any specific questions. And I thank you all for coming out this evening.